All rise. The Lawyer of the Apes is now in session. How's it going, everybody? Wasn't going to do a video this weekend, but one of my followers, Eduardo Mineo, had sent me a link to something on Reddit that he had seen. I'm not really on Reddit, so I don't really follow it. I'm not really sure who Superstonk is. I'm not sure about much of the information that floats around about on Reddit. I usually like to, get my information off of, government websites and stuff like that. So I usually don't like to comment on things that I see on Reddit, but I thought this was interesting. And some of the things that he mentions in this post are interesting, and I don't have enough information, so I really can't give a detailed analysis on what's going on, but it is interesting. So this was posted on Reddit, it looks like, where somebody named Jason, it says that he sued GameStop, right? He shows a certified, mail receipt showing that they sent something that we don't know what it looks like. I haven't seen the complaint. I don't know, what, it says or anything like that. But Superstonk, he got his hands on it. And it looks like he did, a little bit of an analysis on Delaware corporations, because GameStop, even though they're in Texas, they are a Delaware corporation, and there's a whole bunch of reasons why they do that. He goes into that. And then he basically, he starts to speculate as to what, this person could have sued for. So basically, the analysis is, it's general, it's good, but it's just like, a very general idea. So I just want to get into it a little bit more. Again, it's pure speculation at this point, because I don't know what Jason actually requested, but it seems like he had sent an email, right, to GameStop Investor Relations based upon what Superstonk had published on his page. And it seems like he asked for a bunch of information about data in the voting, certified publicly released results. Are you aware of the publicly released numbers of 6/9/21, 8,000 reflect an extra vote cast, etc. So just asking for all this information. So, can a person, make a request for this information? So basically, Superstonk points out that there is a section of Delaware law that basically says, you can request books and records. You can make a books and records demand pursuant to section 220 of the law. Now, this description of it really makes it sound like, oh yeah, they could just put in this request and they'll get it. But it's not as easy as this is portraying it to be. Nothing is easy. So first and foremost, the one thing that I'm concerned about right off the bat is that this was an email, right? This was an email sent to GameStop, and section 220 of the law of the rule actually says that before you can file a lawsuit requesting a violation of section 220 or forcing a corporation to comply with the 220 request, you actually have to submit a formal demand letter, and the demand letter has to be under oath, which means it has to be it has to be a sworn to document. So it's not like they could just write an email, right? It basically says that you can put in a request, but your demand has to be under oath. And under oath is defined as statements that are declaring affirms to be true under the penalty of perjury. So that's the first thing you have to do, right? This person, if they plan on doing it, and this is not legal advice, they should seek, legal advice on their own. But this is just my analysis of it. And what I would do if I was going to be doing something like this, I would write a formal letter, on paper, not via email, and it would have to be sworn to under oath. Now, the demand has to be sent directly to the registered office in Delaware or its principal place of business. So basically, the stockholder can put in their request, but the request has to be sworn to. You have to do a formal sworn request. Now, you can't just ask for anything, right? The section doesn't say you can basically ask for whatever you want. There has to be what's called, proper purposes, right? In order to. And some examples of proper purposes based upon a review of the statute are the value of the stockholder's interest in the corporation, or to investigate mismanagement or wrongdoing. Now, these are just examples of what you can request and the basis for making such a request. But remember, in order to do so, you can't just randomly say, and go on a fishing expedition. You actually have to show some tangible evidence. A stockholder must present some credible basis from which the court can infer that mismanagement, waste, or wrongdoing may have occurred. So that's very important. So it's something to keep in mind. You really have to have a lot of information in order to make this request. So Section 220 allows you to make a statement, and remember, it has to be under oath. You can ask for a list of stockholders, you can ask for a corporation stock ledger, and you can also ask for other books and records of the corporation. Now, remember, it's very important that these demands for records that you make to the Court of Chancery, they have to be very narrow. You can't just make broad-based requests. It has to be a very specific request. So basically what happens is you submit this formal letter, right? Sworn to under oath to Gamestop. Then they have 5 business days, right? They have 5 business days to comply with your request. And it has to be a formal demand. So one of the reasons why maybe they didn't respond to the email is because they know that it's not a legitimate, request under Section 220. That it's 220 request has to be done under oath and in writing. And since this is a statutes are strictly construed by the courts. So this is probably an element of the statute that you have to do to get your foot in the door. So after 5 business days from when you served your request, then and only then can you file an action against the corporation for a 220 request. So that's basically what you have to do, right? And then once you get your foot in the door and you file the complaint against the corporation for failing to respond to you, then it takes about, the process is not something that's going to be done quickly, but it's definitely quicker than general litigation. Probably looking at like 90 days. You can get some discovery through this process, but it has to be very narrowly tailored because obviously you're asking for documents to begin with. So, that you're actually seeking discovery in reality. So, then after that, the company can still object to it and they'll tell you the reason why they're objecting to it. And then a trial would be held, right, before the Court of Chancery. And the Court of Chancery will decide whether or not the request falls within the statute, whether it's narrowly tailored enough, does it fall within one of the, recognized bases for information, are these requests, really based upon genuine facts, or is this, what is called a fishing expedition? So again, I don't know enough about what he's seeking or what he did, but if he is relying upon those emails, my analysis would be that those emails are not going to be enough to get your foot in the door for a 220. So as more information comes out about this, I will be keeping an eye out and I'll continue to comment on it. But I just thought it was interesting, and I think it's important, to get the right information out there. Not to say that Superstonk didn't give good information. He did give a a very decent general analysis. I don't think he said anything that was untrue, from a legal perspective. But some of this stuff from a legal perspective was inaccurate because those emails are not sufficient, to get your foot in the door for a 220. You really have to do a sworn letter directly to the corporation under oath. All right, guys. So that's basically it for today. Hope everyone enjoys the rest of their weekend. Until next time, the lawyer of the apes is adjourned.